Title of my presentation at this Elimination of Violence Against Women virtual conference is Violence Against Women in Nigeria, the Dynamics of Law and Society. The question of violence against women is of global concern, it's a global problem, and it's a national problem. And in Nigeria, the dimension and the proportion of violence is worrisome. There are reports that at least 25% of women in Nigeria go through one form of violence or the other, making violence against women a major social and health issue in Nigeria. The underlying causes of violence against women in Nigeria traverse all the forms, both in private and public space. The efforts of Nigeria to regulate and prevent violence against women is, to say the least, embracing of both civil and criminal processes, which provide a regime of protection and compensation for victims, and sometimes imprisonment as punishment for violators. Nigeria has made spirited efforts to embrace all the global standards regarding the elimination of violence against women. Ample policies like National Policy on Gender, which replaced National Women Policy, attempt to provide a legal terrain of equality and non-discrimination against women, and also to mainstream gender considerations into such areas like health and education. Against this backdrop, one would expect that violence against women would cease to be, or at least gradually cease to be, a major challenge. But this has not been the case. The space continues to expand, and the question that necessarily arises is, what's next for law in the regulation and prevention of violence against women? The authorities of legal regulation must embrace internalization processes, as well as justice that is accessible, that underscores the values that promote the dignity of the human person, male or female. The argument today is that we must move beyond prosecution to entrench such mechanisms that exclude violators from core benefits of society, both in the private and in the public space. For example, engagement in prevention and the publication of names of violators. It's an engagement of society that violence against women is violence against humanity. It is violence that is perpetrated because of the considered inferior status of women. When you violate a woman or you perpetrate violence against a woman, you are violating humanity. The continued fight to eradicate violence against women in Nigeria continues to stand on shaky ground because of the interplay of culture, religion, and socialization, and the patriarchal structure of the society. And so we ask that question. The popular and the widely accepted description or definition of violence against women is that violence that is perpetrated because a woman is that is perpetrated against a woman because she's a woman, or that women suffer disproportionately as against men. The status of womanhood has implications for social justice, and you ask yourself, what is this status? In Nigeria, women have been seen as property, as inferior, as occupying only the role of creation and not production. And violence against women is a gender-based violence that is perpetrated by the state or private persons or institutions or cultures. In the Nigerian society, women suffer compound injustice because of their status as wife, as mothers, as daughters, as widows. In fact, any status that you can put a woman into. And any discussion on violence against women must engage the understanding that violence against women is a violation of the fundamental rights of women. The dynamics of Nigerian society is that it has over 500 ethnic groups and it is multi-religious. The institution that permeates the Nigerian society is patriarchal, with a denial of property rights for women in marriage, in divorce, or when they are in widowhood, lack of inheritance rights, lack of voice, and a culture of silence about violence against women, sometimes endorsed by the state. Theories of gender have identified socialization, economic dependence, and patriarchy as major causes of violence. Coupled with underdevelopment, job insecurity, and the informalization of women's work, as well as their non-valuation, continue to play a major role in ensuring that violence against women does not have the necessary attack that it deserves. The forms of violence against women that are globally recognized are all domiciled in Nigeria, despite the many laws that have attempted to either criminalize them or provide compensation. Talking of female genital mutilation, trafficking in women, sexual violence, sexual harassment, harmful traditional practices like widow practices, and early and forced marriage. The challenge of regulation in law is major concern to this description, to this work. Legal pluralism, in which sense we mean that Nigerian society has different forms of law that are valid. Customary laws, religious connotations of law, English laws, Islamic law. And then legal dualism, which ensures that international instruments that we have subscribed to are not domiciled or domesticated in Nigeria until there is a domestic law that puts them into place. Gender ideology and woman ideology, which we get in Nigeria, feminist ideals as being Western and does not embrace the equality of women and their social and human rights. We also have the challenge of women being perpetrators of violence and also accepting violence as normal in relationships. Then the issue of public and private divide, which ensures that most cases of violence, especially domestic violence and intimate partner violence, get unreported and unpunished because of the culture of silence concerning the private sphere. These and many more create challenges of legal regulation. Nigeria has made some global commitments to eradicate violence against women, from the Convention on the Elimination of Discrimination Against Women and the African Charter on the Rights and Welfare of Women, as well as the Maputo Protocol, as well as a legion of laws and regulations at global and domestic level. The Constitution of the Federal Republic of Nigeria and some domestic laws like the Domestic Violence Law of Lagos State and some other states, and the Violence Against Person Prohibition Act, as well as many other laws, provide a legal framework for prevention and punishment of violence against women. But these laws, as much as they can be deterrent in value, have not provided a mechanism for internalization of the values that promotes the dignity of the human person and especially of women. Institutional arrangements for redress structure must embrace the component of putting the right ideology in the socialization process in Nigeria. Until this is done, law and regulation will continue to be a far cry from the dynamics of preventing violence against women. It must be understood that violence against women is violence against the whole world. Its impact reverberates all dimensions of a woman's life. And when you eliminate violence against women, you eliminate violence against the world. This is not a job for law alone, but for law as an instrument of social engineering and a complement of society's internalization of the rights of each person, male and female, to embrace a just society. Law must move from the rhetorics of stipulation and prohibition to a culture and a mainstreaming of measures that can eliminate violence against women in all aspects of life. Thank you.